the issue of qualification or disqualification will only arise in the context of an election, that jurisdiction is completely ousted by Article 225 of the Constitution and the judgments of your Lordship. Your Lordships have said no election will be called in question. The meaning under Article 225 of the Constitution, and your Lordships have said in Javed Hashmi's case that election starts from the time the Election Commission notifies the schedule till such time that a candidate is declared, returned or elected. The decisions of the election tribunal, your Lordship have said in Raza Hayat Hiraj's case, cannot be called in question even in a writ petition.
Prior decree B cannot be used.
My Lord,
suppose there is a prior decree before the start of election that cannot be used in the...
My Lord, the prior decree will only say whether I have paid my debt or not. Now, in that case, as my Lord, Mr. Justice Yahya Afridi identified, there will be a disqualification attracted under Article 63 of the Constitution. No declaration under Article 62 of sagaciousness or righteousness. My Lord, which, your Lordships, with your vast experience in civil law, which civil court, when passing a decree, even in a banking suit, and says this money is outstanding, then goes on further to declare that this person has ceased to be sagacious,
So that's the question. Can you just go back, Mr. Makhdoom?
My Lord.
We cannot attribute redundancy to the Constitution, even though it's quite clear that there's no such declaration that can come from any court. But we have to give meaning to because we can't just throw it out. So making an effort to giving it a meaning, this paragraph is crucial in Samiullah, that the declaration they're talking about is arising out of civil jurisdiction, inter-party litigation. So, for example, there's a case where a sale deed has been struck down as being fraudulent or forged. Now, there it has been, as a consequence, we understand that that person has committed fraud because he came up with a fraudulent sale deed. That is a bit of a construction that we have to do just in order to justify this declaration given in the court. Having said that, all the other declarations which are coming in through original jurisdiction and the writ jurisdiction not arising from civil jurisdiction are out of the canvas, right? So let's first specify that the declaration we're talking about is inter parties arising out of civil litigation.
Right.
Now, in the absence of 232, we would have had to construct what is to be done. I'm just saying that legislation could, not justifying 232, but legislation could say that for the purpose of election, such a civil, such a decree which is arising out of civil litigation could have a time frame for purposes of election. So the question is, can legislation put a time frame on this declaration? Could that be possible? Not the way it's worded in 232. My question to you is that, first of all, Samiullah Baloch helps us identify that which declaratory decrees we talk about, which declarations are relevant. Declarations arising out of civil jurisdiction, which are inter parties, number one. Now, could legislation, not the way it is done today, but could legislation say that this declaration will continue forever between the parties, but for the purposes of election will have a time frame?
My Lord,
such a legislation is not the way it is done now in 232, but could such a legislation be possible to say that a declaration inter parties arising out of civil litigation for the purposes of election would only be for 5 years, even though between the parties it will remain forever till it is set aside, but for the purpose of election? Could such legislation take place?
My Lord, that was a bit later, but may I address it right now? My Lord, when your Lordship looks at 62(1)(f), the constitution makers under the 18th Amendment do not say that this is a declaration of a civil court. They say no declaration to the contrary by a court of law. A criminal court is as much a court of law as a civil court. Now, if your Lordship reads a court of law as a court of law, a court of plenary jurisdiction, that would include courts both on the civil and criminal side which decide cases after recording of evidence. And in that, if your lordship does that, then 63 and 62 will have to be read together. There's no way one can read them differently. My lord, may I just preface this a little further? Sure. My lord, a question has been asked and repeatedly that, and my lord Mr. Yahya Afridi asked that again yesterday, why have two lists? Justice Hilali asked the same question again. Why have two lists? What's the difference? My lord, the two lists made perfect sense under the original 1973 Constitution. The list of qualifications was that you should be a citizen of Pakistan. For MNAs, you should be 25 years of age. For senators, you should be 30 years of age, and that is where the qualifications ended. All three were qualifications. The disqualifications were that he is of unsound mind, that he is an undischarged insolvent, or he ceases to be a citizen of Pakistan or acquires the citizenship of a foreign country. When your lordship looks at them, there is no disconnect. The qualifications are separate, the disqualifications are separate. Sorry, there is a disconnect. They deal with two different subjects. One where a qualification is acquired, one where a qualification is lost in a way, or a disqualification occurs because the person loses sanity, or the person loses citizenship, or a person becomes an undischarged insolvent. The moment the court declares that person as insolvent, then the disqualification is removed. The moment there's a declaration that the person is of sane mind, the disqualification is again removed. The moment the person acquires the citizenship of Pakistan or sheds his foreign citizenship, the disqualification is again removed. The disconnect...
एक क्वेश्चन पहले भी पूछा है, पर उसमें क्लैरिटी नहीं आ रही कि 62 Article 62 applies pre-election, post-election, or at any time.
My lord, the way I look at it, election 63 applies at any time.
Yes.
62 applies only at the time of election, because he shall not be qualified to be elected or chosen as a member of Majlis Shura.
At the time of filing nomination.
Yes, my lord.
And a person files his nomination and his opposer submits some document before the returning officer that something, yeah, decree has been passed against him, so he is not eligible to contest the election.
My lord, yes.
Is it your meaning?
My lord, my submission...
By the declaration of law, because opposer can file the application, his nomination form should not be accepted because he is not eligible to contest the election.
My lord, yes.
So what is the main interpretation of Article 62, whether it applies at every time, it applies before the election, or any time after election?
My lord, when your lordship looks at 62 and 63 and reads them together, because that's where I was coming to, after 1985.
What is the difference between the opening language?
My lord, the opening...
person shall not be qualified to be elected, and if you look to 63, a person shall be disqualified from being elected. So there must be some distinction between the framers of the Constitution.
My lord, may I...
If I may interject, Mr. Makhdoom Ali Khan, and it may help you to respond to my lord as well. Somehow, as I see it, we've got bogged down in restricting ourselves to reading just a particular provision of the Constitution. And we seem to have forgotten the Constitution as a whole. What is the Constitution all about? What does it do? What are the fundamental rights? Article 17, more importantly. And we are going to a particular provision of the Constitution and just reading those and disregarding everything else. We're disregarding the history of Pakistan. We're disregarding the constitutional history of Pakistan in particular. We're disregarding the fact why these amendments were brought into the Constitution. We're disregarding the fact that original Constitution has a greater sanctity than amendments brought there too, unless there are such amendments which enable to serve the people better. For instance, Article 19A, Article 10A. Now, nobody can say that these insertions have taken away something from the people of Pakistan. Rather, they have given something to the people of Pakistan, including Article 25A, compulsory education up to the age of 16. And these are on the contrary, an insertion into the constitution, and they have not been one insertion. They start with General Ayub Khan, and successively more and more encroachment into who I will determine will be fit to govern Pakistan. First of all, the initial question will arise, who am I to determine this? Why can't the people of Pakistan themselves determine? Oh, so what? Disregard how it came into the constitution. Now you're stuck with the language of the constitution. At least I am not persuaded to adopt that approach. I cannot forget the history of Pakistan. And unless you can say they are very beneficial things, we had given public notice in prominent newspapers. Not a single political party has come before us which has said, leave alone those who are not even in parliament, said that this is a good interpretation of the constitution. So then we come into, there is another aspect which I consider. There are things which are specifically mentioned. If, for instance, for theft, you mention a particular sentence, and if you say for a trafficking offense or for some other offense, there may be a punishment. But for instance, the legislature forgets to mention for what duration. You can't possibly say, oh, I'll impose a punishment for murder here. There must be some logic, there must be some reasoning. The reasoning is, you destroy Pakistan, that's fine. You can contest elections for 5 years. But if you make a single mistake in the nomination paper, you're disqualified for life. Now, we are just stuck with the wording of it. Have we lost all logic and sensibilities? I mean, why are we not? Nobody's addressing that. I keep requesting that to be addressed, but we are just bogged down by this 62(1)(f) and the whole of Pakistan, because a general decided to impose that, has now got us thinking. Leave aside the constitution of Pakistan, we're just stuck with his language. So can we just what I really wanted from you as a constitutional expert was to expand our vision and not restrict it. And everybody's just working on those particular wordings. How does this mean? What does this mean? What does a court of law mean? Is it a court of plenary jurisdiction? Is it a constitutional court? Yes, those are necessary, important questions. But in context, in the order of priority, I would put it at number 10. Probably, if there are 9 other more important ones. Sorry, I went on a bit too long, but can you focus on those aspects?
Let me, my lord, that was, in a way, your lordship's observations connect and resonate with the question posed by my lord Mr. Justice Sayyid Mansoor Ali Shah. My lord, how? That the qualifications and disqualification as envisaged by the original constitution makers made perfect sense. That if you could disconnect them at a time, they made perfect sense because they dealt with 2 different subjects. In 1985, under Presidential Order of 14 of 1985, which we call the Revival of Constitution Order, all these changes came about with a minor change again through the 18th Amendment. At that time, where a whole host of disqualifications and qualifications were added. And when these were added at that time, virtually we lost the plot. And it would be difficult to say that 62 and 63 are now disconnected provisions. They are connected, they have to be read as a whole. Now, insofar as those amendments were concerned, they virtually were envisaging, as observed by one of your lordships in an earlier 7-member bench judgment, virtually a society of angels and parliamentarians who were probably even holier than angels to come into parliament. So there was a disconnect with real life, I mean, which reminds one of, your Lordship's observations remind one of the quotes of Abraham Lincoln, that it has been my experience that folks who have no vices have very few virtues. So virtually introducing a society of people with no vices and few virtues. But my lord, in these qualifications and disqualifications, these very long list, there is a connection. And the connection is that you cannot read Article 62 without looking at Article 63. And even earlier, you could not read Article 62 and 63 without being conscious of the rights of citizens under Article 17 of the Constitution. This court has always been mindful not to disenfranchise people, that the right of people to form and join political parties is there, and a person has a right to contest elections. 62 and 63 both make inroads to an extent under that fundamental right. The inroads were sensible inroads when it came to the original 1973 Constitution, that we will not allow an insane person to be a member of the parliament, that we will not allow an undischarged insolvent to be a member of parliament, we will not allow a person who is not the citizen of Pakistan or is the citizen of another country to be a member of parliament, that we require that persons should be at least 25 or 30 years of age, being National Assembly or Senate respectively, to be members of parliament. And that none of those make an inroad into Article 17 of the Constitution.
So why are we interpreting it in this manner then? And then something has also been said that ordinary legislation is not a substitute for a constitutional amendment. Okay, you bring in a constitutional amendment, we strike it down. So our wisdom is paramount.
My lord,
so we can do whatever we want to, not guided by anything other than our own vague ideas of morality.
my lord, and that is the submission, that two things you will not find. You will not find a judgment from the common law jurisdiction where by a declaration of the court, because this is not a declaration of parliament, my lord, Article 63. And
will you concede that I mean, this is no disrespect to anyone, will you concede that the parliamentarians in Pakistan are the best in the world? Are the best in the world? Surely not. I mean, don't be hesitant.
No, my
There's
lord,
no disrespect to anybody.
No.
Does any other country, a single country in the world, have this test for parliamentarians?
My lord, not that I am aware of. Not the US Constitution.
So if we have this test and we don't have the best parliamentarians in the world, that means this is not even a workable law, if at all anything else. I mean, it's just words on a piece of paper which I can use for my personal projects, I would say. Tomorrow you are honest, you can be declared dishonest, out, in, it's up to me. I can just write some few words of English language and that's that.
To give an immediate example, the US Supreme Court has a similar requirement: citizen, age.
Those are, you can physically,
Yes.
you can checklist, yes.
Like we had in the 73 Constitution. Even when the US Congress sought to introduce new qualifications of this kind at a particular period of time, in Powell versus McCormick, the US Supreme Court struck it down. They said no. The Constitution has given a list of qualifications. Congress cannot add to that list of qualifications. That's where we stop. So the courts in other places have gone the other way. They've said, here is
Mr. Mazloom, like speaking for myself, we'll have to, expounding the Constitution, we have to rely on the tools of interpretation.
My lord, yes.
I look at the Constitution post 18th Amendment. To me, the dictator argument is out of the window because it is the 18th Amendment passed by the Parliament. So I need to give it a very serious thought in interpreting the Constitution. So every word to me is important. I could just disregard all the words and say this is not the Constitution. That cannot happen, even though I might disagree with the wording of it, but some meaning has to be attributed to it. I find the declaration personally making no sense, but I have to give it a meaning because I can't throw it out of the Constitution. I don't have the jurisdiction to do that. So having said that, you were at that moment explaining that the court of law could have criminal and civil both. Could you just resume from there and explain?
A court...
Can you also attend to a side query with what my Lord has just observed? My Lord is, with the greatest of respect, assuming that there will be redundancy to the Constitution. I would reframe it. There would be redundancy to the interpretation of the Constitution by this court, which is not quite the same thing. The Constitution does not say that you stand disqualified. We say you stand disqualified.
My Lord,
if the Constitution had simply said so, end of story, fine, that argument would be. But it is how we interpreted the Constitution has said so. I don't know if that's a valid point or not.
May I, as counsel, mediate a safer course for myself by saying, by saying.
No, please, we never mind anything being said here.
No, my Lord, because
you see, we bounce ideas, our thinking clarifies.
My Lord, take the hard response.
My Lord,
be as critical as you want.
My Lord, the safer course which I suggest for myself is that when your Lordship looks at the Constitution, whether your Lordship looks at it, my Lord, as my Lord the Chief Justice is looking at it, or my Lord, your Lordship Sayyid Mansoor Ali Shah Sahab is looking at it, there is no redundancy. Redundancy is created by Samiullah Baloch. If your Lordships read the Constitution the way Samiullah Baloch reads it, there is redundancy. If your Lordship reads the Constitution, the legislature intended it after the 18th Amendment, there is no redundancy. Because if a court of law includes a court of criminal jurisdiction, then it immediately takes your Lordship to the provisions of Article 63, 1G and H, and there the limits are specified. Their Lordships then make a further distinction, and that's again Samiullah Baloch, that a person who has been convicted has then paid his debt to society, forever suffers the odium of being a convicted criminal, and therefore he is in a different league than from a person who suffers a civil liability. Parliament doesn't make that distinction. The court does. It is the interpretation of the court which is making the Constitution redundant. My Lord, that logic also does not hold. Why it does not hold? My Lord, in criminal law, and my knowledge of criminal law is very, very peripheral, and your Lordship will excuse me for that, but I make a distinction always between conviction and sentence. A person serves out a sentence. A person never serves out a conviction. The conviction remains on his record forever and ever. If he has served even till the rising of the court.
Baghdub Ali Khan, that's another matter which is pending adjudication in this court. I am of the view, and others of a different view, and I had requested for a larger bench to be constituted, and I'm maybe failing in my duties not to have done so myself, but so much has been happening, we're working morning to night, was that in a murder case, 345 allows compounding of an offense. There are two views in this court prevailing. One view is it brings the sentence part to an end. It does not efface the conviction. The other view is it effaces the conviction and the sentence both. So even if we apply that debt to society part, suppose a person commits murder and next day secures a settlement with the legal heirs, where is the debt to society has been paid? It hasn't been paid. He will file a nomination papers. Have you been convicted of an offense? Answer will be no. If that interpretation of the Constitution is followed, which says that it effaces the conviction and the sentence, he will honestly answer no. Whereas if the interpretation which I have favor holds, he will say yes. Sentence part would be a different part. So even though he didn't pay debt to society, did not serve one day in jail, he still can contest election in that scenario. So this debt to society argument I also find a bit fallacious.
Well, that's this.
I guess let's wait for a larger bench on that question, because that will take us yet to another argument altogether.
I think we should not be a member of that.
For the debt to society argument,
It's already there, by opinion, written.
debt to society argument in the Samiullah Baloch case, when your lordship looks at 63(1).
So, Mr. Makhdoom, I mean, taking up that argument that you said, court of law could be both. So when it's criminal, then of course 63 gets attracted, but when it is civil, 63 doesn't get attracted, it stays where it is, and we have to deal with it.
Yes.
So there is a declaration which is civil, arising out of original jurisdiction, the way we're looking at it, and is calling somebody a fraudster. Now the question is, how do we put a time frame on it? There's a decree standing in your face saying that you're a fraudster. Now what do we do with it? How do we treat that decree and think of it that it has a time bound or it doesn't? Because inter-party it probably stays forever.
Lord,
but for elections, should we take it differently?
Let's come to the time bound question.
Yes.
Time bound question immediately.
I will add to my lord, whether that time will be started from the date when decree was passed or from the day when the elections are called.
Because also that there's no dispute to the fact that inter-parties that stays forever.
Inter-parties?
That stays forever.
Inter-parties that stays
unless it's set aside, of
Yes,
course.
that's true.
But for elections, perhaps a different treatment needs to be given.
And my lord,
how do we do that? That's
for the reason is, Parliament over here, even in the 18th Amendment, doesn't say that the declaration will remain forever.
Right.
They are silent, and they're silent from D and E and G don't talk about a declaration at all, but again don't mention a period of time.
Right.
F mentions, don't mention a period of time or mention a court. F mentions a court. Now, is this declaration going to be, as was pointed out by one of the amicus, till the time of the next election, for the present term, or forever? Generally, when your lordships have looked at questions where no time has been specified, your lordships have consistently taken the view that it has to be a reasonable time. My lord, to give an example which obviously comes to mind from civil law jurisdiction, there is no time specified for filing a revision under section 115 of the CPC, if I correctly remember.
Before it has been inserted 90 days.
90 days.
Now it is 90 days, but they didn't used to be, even when there wasn't.
Before we come to that reasonable time argument, first of all, you need to understand the basis. If the decree stands for life till such time that it's set aside between parties, why should it be given a different treatment for election purposes? What's the philosophical answer to that? Because if inter-party it stays forever till such time it's set aside, how would it be different, or why should we even consider it to have a time frame for the purposes of elections?
My lord, for two reasons. Number one, if that decree comes in the context of elections, it is simply impossible. An election tribunal makes one of the four declarations. It either dismisses the petition, or declares the election as void, or declares the election as void and directs that the particular candidate may be declared as a returned candidate, or declares that the election to be void as a whole.
Re-election.
That used to be the situation under ROPA. That is the situation even now under the Election Act. For offences under the Election Act, for corrupt practices, for illegal practices, the session judge tries them. Now some of them tried by Election Commission, some of them by the session judge, and we need not go into that question. PPC itself has a chapter on election offences and where punishments are prescribed. Your lordship will notice that when your lordship looks at corrupt and illegal practices, the maximum punishment of illegal practices in none of those cases exceeds 2 years. So only for the corrupt practice that it can go for a longer period. The principle of proving a corrupt practice is beyond a reasonable doubt, and therefore my respectful submission is that the court, the parliament was thinking of those kind of declarations when it talked about a declaration under 62(1)(f). This business of a civil law declaration, with great respect, has been introduced by this honorable court, introduces that a civil liability will virtually strip a citizen of his fundamental rights forever and ever. That was not something which the parliament has done, because if your lordship reads F with G and H, they make perfect sense.
अब देखिए मखदूम साहब एक बात और जरा, सपोज अगर कोई कोर्ट, सिविल कोर्ट से डिक्लेयर समबडी दैट ही इज चीटर, ही हैज चीटेड समबडी, मेक्स फ्रॉड, कमिटेड अ फ्रॉड, और उसका राइवल जाके उसके खिलाफ एफआईआर दर्ज करता है अंडर पीपीसी सेक्शन 415 एंड 420, और एफआईआर के बाद ही इज कन्विक्टेड, कन्विक्शन के बाद तो वो उसको सजा मिल गई, क्या फिर भी वो सारी जिंदगी ऐसा ही रहेगा कि वो is debarred from contesting elections?
Sir, in that situation, you will have an absurd situation. The absurd situation would be that on account of that civil liability, he will be forever disqualified. But insofar as the criminal liability is
I'm
concerned,
talking about civil declaration. किसी के खिलाफ डिक्लेयर कर दिए,
जी सर,
वो तो टाइम नहीं देगा. सिविल कोर्ट तो ये नहीं कि you are debarred from, वो सिंपल कहेगा you have committed fraud
जी जी,
by changing the documents और जो भी है. दूसरी पार्टी कहती है कि चूंकि आपके खिलाफ एक डिक्लेरेशन आ गई कि आपने चीटिंग की, वो जाके एफआईआर दर्ज कर देती है. एफआईआर की बुनियाद पर पीपीसी में जाके क्रिमिनल कोर्ट में चल रहे तो वहां पे सजा हो जाती है 2 साल 5 साल जितने भी. क्या सजा खत्म करने के बाद स्टिल उसके सारी जिंदगी डिस्क्वालिफिकेशन
5 साल?
सर 63(1)(H) के तहत उसकी डिस्क्वालिफिकेशन खत्म हो जाएगी. लेकिन अगर
आपकी वाली बात है कि उसको 63 के साथ पढ़ा जाए,
अगर समीउल्लाह बलोच सही फैसला हुआ है, if समीउल्लाह बलोच has been correctly decided, then on account of that civil declaration against him, he will be disqualified for life. So in spite of the fact that under a criminal declaration he has paid his so-called debt to society, under the declaration made by civil law,
debt to society argument कहीं constitution में है?
नहीं है.
नहीं तो देखिए वही बातें हैं, we're getting bogged down into things. When the constitution itself grants parliament the right to disqualify for periods of time, the only argument left is that since this matter falls in 62(1)(f), therefore parliament can't do it. Where's the logic of this? I don't understand the logic of it. At the end of the day, बाकी नैब लॉ में उन्होंने 10 साल कर दिया है, दूसरे लॉ में ये कर दिया, फला कर दिया है. क्योंकि 62(1)(f) में नहीं है तो हम और ज्यादा कर देते हैं. मुझे I don't understand. I mean, everything must be logical. I mean, we are not philosophers determining points or fine points. What is the logic? How will you persuade? After all, this document is not for lawyers. This document is for the people of Pakistan. Please explain to the people of Pakistan why a NAB convict will get 10 years disqualification, another will get this type of disqualification. But if in your nomination paper you have a provision, and I can ask you this question and let's see if you can answer it correctly. It says how much gold you have in grams. Will you go to and weigh it at home? How much gram gold you have, you make a mistake in that, or forget to mention a ring that you're wearing or your wife is wearing, and you are disqualified for life. Please explain. I mean, let's not get so bogged down in constitutional niceties where people of Pakistan lose trust in the constitutional document of Pakistan. That is very important. Please explain it to, because you are on live television, explain it to the people of Pakistan, the logic of it.
My lord, because it's a 5-member bench judgment of this honorable court, may I respectfully submit that the logic is too subtle for me to decipher. I find
you can assist us.
And I presume you are fairly educated, Mr. Makhdoom Ali Khan.
My lord, I would like to think so, because otherwise I would not be qualified to practice at this bar, my lord.
So talking about logic, which the Honorable Chief Justice, and taking that further, if a convicted person, a conviction, as you said, stays, if a convicted person can come back and contest election, so it appears that the Constitution is treating election as a totally different ballgame.
Yes.
And looking at convictions and decrees.
Yes.
So if a person who's convicted can come back, then a person with a decree can also come back.
And my lord, some of it may have history behind it. Your lordship may look at AG much more than an offense of moral turpitude is the offense of somebody who is historical basis. If we go back in the history of the world, not just Pakistan, it has a historical basis. My lord, the Americans fought a civil war. Two states, there was a confederacy and there was union. Mr. Jefferson Davis was the president of the confederacy. Mr. Jefferson Davis, the prosecution against him collapsed. His vice president, 2 years later after the Civil War, was elected to the US Senate. Why? The idea was to bring the union together, not to keep the people permanently disqualified from participating in the democratic processes, because it is participation in the democratic processes which holds
Who was the vice president?
My lord?
Who was the vice president?
My lord, I have the name, I keep forgetting it. G. Sorry.
American history.
Alexander Stephens.
And he returned to the Senate in January 1866 and but to General Sherman, saying that, you know, as president, I would be bound to oppose Jefferson Davis getting away. But if unbeknownst to me, Jefferson Davis were to escape, I would not hold it against you. So he was basically saying, now that the Union has won the war, the country has come together, look the other way, let healing take place, let reconstruction take place.
He's saying the Constitution talks about strengthening democracy through the process of elections,
yes,
and it is saying that even convicted persons who serve their terms will come back and participate, because participation in election is perhaps a larger principle at work. People need to come back into elections because that then strengthens democracy.
Yes, my lord.
And let the people to decide who is righteous, who is Amin, who is...
Mahmood sir, I just wanted to know whether this part of the article is towards the whole society, the court be giving a decree against the whole society, like he is dishonest towards the whole society, or what? Like if I have a problem with someone and the court pass a decree against me in that particular case, but towards the whole society, I'm a very pious person, rightful, what would be the effect of that decree? Why should that constituency, the people of that constituency, lose a rightful person? But in a particular matter, he was declared as a dishonest person.
I bow to that observation. That is absolutely correct. That, and taking from that, your leadership's observation to what my Lord Mr. Justice Mandukhel identified, that is really the issue over here, that you have created both a debt to society concept and you have created a civil court. My lord, the court talks about af or toba or forgiveness. Now, how will the forgiveness come? They say that forgiveness is to come and this declaration is to be remained till it is removed. How will it be removed? My lord, take the example of the applicant intervener in this case. This honorable court disqualified him. Could he have gone to the civil judge Lodra and got a certificate or a declaration after 2 years or after 6 months or 2 months that I have become very penitent, I am pious, and now please give me a certificate that I am non-profligate, honest, sagacious, sadiq and amin, and that would have washed off the disqualification finding by this honorable court under 62(1)(f) of the Constitution. This is a court, my lord, with great respect, and I say so with the utmost humility, like many other concepts in this judgment, which is pure invention.
Abdul Sahab, I am still waiting for my answer.
My lord, this submission in your lord...
And it will be triggered at the time of nomination, or this will be seen by the election tribunal. It is very
separately read in isolation, it is triggered at the time when the person files his nomination papers, at the time when the process of election commences with the issuance of the election schedule. If your lordship are to read the two articles together, then the words, my lord, qualified, elected or chosen are also there in 63. Then even if he passes that initial barrier and contests that election, but it is discovered that he suffers from a lack of those qualifications, then under 63, that will survive. So if your lordship is...
Who will see that? Election
tribunal. Election tribunal. My lord, because your lordships have held repeatedly that an election as provided in the constitution cannot be called in question in any other manner except through an election tribunal to which an appeal lies, from which an appeal lies to this honorable
before
court.
the tribunal, the person who is contesting the candidature of that particular elected person, he has to produce that declaration that please see that it was not placed earlier before the returning officer.
Yes, my
so
lord.
he's not competent.
Yes, my lord.
You mean to say?
My lord, 63 does not talk of a declaration, so he will have to say that this person, now because of the language of 63, he was somebody who was disqualified from being elected, and therefore the 62(1)(f) declaration which I am now producing, you have to look at and disqualify. Now your lordships have said in Javed Hashmi's case that from the date the election schedule is issued till the time that a candidate is declared return, that is the process of election. And your lordships have created a very narrow window in Ghulam Mustafa Jatoi, where your lordships have held that where a candidate who has been disfranchised and his grievance cannot be rectified either during the process of election or post-election can come in a writ petition, where there has been a blatant illegality and disenfranchisement, so virtually referring to Article 17. Out of that narrow window, the bar of Article 225 is reasserted again and reiterated by a bench headed by Honorable Mr. Chief Justice Nasrul Mulk remains. So this declaration will not come from any court of civil jurisdiction, because a court of civil jurisdiction will say that in the context of elections, I do not have the jurisdiction to make this declaration.
One more question. At the time of filing nomination, the person who is opposing the candidature placed something on record, and then the RO decides you are not eligible to contest the election. Is it the declaration?
It is not, because RO is not a court of law.
Only civil jurisdiction.
That definitely is not in this honorable court.
And then what would be the position? He will place on record something that earlier this declaration has been passed against this man, so the RO can reject the form.
My lord, that has to be a declaration by a court of law under 621F. And if there is, and that declaration is there now under 621F, he can make that. My submission is that this is a situation which is more a product of legal imagination than legal reality, because such a court does not exist.
High Court can grant declaration.
My lord, High Court under Article 199A2 can issue, in my respectful submission, both writs of declaration and writs of certiorari. That language is wide enough to cover both. But the High Court will suffer from the same limitations insofar as election is concerned as any other court in the country, because Article 225 will come into play. Your lordships have in other cases held that the threshold is even higher, both in terms of locus standi and adequate alternative remedy, when an appeal lies to this court, because we will get an opportunity to correct the error if it was there. That is why, where the High Court interferes under Article 212, your lordships have invariably held this cannot be done, because even if the tribunal is acting without jurisdiction, the matter will come to us under 212 and we will satisfy it. So why should you look at it in 199 or 184.3? It will be back to us under 212.
So Mr. Mazdoor, the question then really is, I mean, once we've cleared this, that the declaration has to be from the civil original jurisdiction, arising out of civil jurisdiction, that's been sorted. The only question is the treatment to be given to the time frame of this civil declaration. Now, the bit of an unease is to the fact that you're reading into the Constitution, or you could interpret it by saying that we can pick up the period from 63 and import it into 62(1)(f), that's one. But what do you say that in the meanwhile, while this was going on, legislation has come about and the legislature has stepped in before the courts could step in, and the legislature has come up with a certain time frame. The question is, does that legislation, I mean, would it not have been better had the legislation been that any declaration arising out of civil jurisdiction for the purposes of 62(1)(f) would be 5 years, would have been a better language, but they went ahead and said that the disqualification period in 62(1)(f) is 5 years. So is there a possibility of reading down 232 and bringing it in line with it and just leaving it to the legislation rather than us constructing a 5-year period, because the legislation has also stepped in already? Could it be read down and that fixes the problem?
My lord, may I begin with an aside and immediately come to it? My 30-second aside is that I do not subscribe to the doctrine of reading in at all. I think it's a very suspect doctrine. Sure. It has no basis in constitutional jurisprudence anywhere in the world.
Right.
This honorable court has subscribed to it in more than one case, but my respectful submission is that the doctrine of reading in has been brought in other common law jurisdictions to save rather than strike down statutes.
That cannot really apply to the Constitution.
And that cannot apply.
Because you're actually saving it for the Constitution.
And my lord, how do you use the doctrine of reading in? You say that we will read the Constitution in this manner to save this statute.
Right.
It has never been used either to give a different meaning to a provision of the Constitution to strike down a statute or to limit the rights of a citizen.
That's why I'm saying, you see, would it not be an easier course now the legislation has come in? Is there a possibility of reading down the legislation and resolving this problem rather than just inventing a period for 62?
My lord, may I suggest, with your lordship's leave, a third course? The third course is that your lordship is hearing 185 petitions. In none of these petitions, a statute is directly...
You're hearing appeals.
Appeals. 185 appeals.
Right.
In none of these appeals now, leave has been granted, the statute is directly under challenge.
Right.
The statute has come in later. There will be, if the statute survives, the legislature itself, the next legislature may repeal it. If the statute survives, there will be cases before your lordship where a challenge is directly made to the statute, and your lordship, after hearing a full argument on both sides, would be in a better position to read down the statute or save it by reading in or strike down the statute. Over here, if your lordship, as your lordship is dealing, your lordship has to squarely deal with whether the Samiullah Baloch case has been correctly decided.
The question that's been framed for us is that not only Samiullah Baloch, but also the insertion of the section. In that context, we're looking at the whole problem.
My lord, if, as was pointed out by Mr. Faisal Siddiqui yesterday, if Samiullah Baloch is overruled, then there's nothing wrong with the statute. It is only if Samiullah Baloch is upheld, then the statute has to be struck down, because a statute directly contrary to an interpretation of the Constitution placed by this honorable court cannot survive.
Because we struck down the section 232 when the matter is not before us.
That's why I'm saying that your lordship should neither uphold it nor strike it down, leave it for another day. That's a submission I made, my lord, unsuccessfully before your lordship in another case, 2-1 of course, where I said that there is no frontal challenge. Wait for the controversy to ripen, wait for the issue to mature, wait for a full argument to be made.
Just one question.
My lord.
Do you subscribe to the doctrine of constitutional abeyance or absences as put forward by Mr. Faisal Siddiqui in quoting Michael Foley.
My lord, I agree with that doctrine that if there is a...
Would you like to expand on it a bit?
My lord, what I may suggest is that if your lordship may look at what the legislature has done, even now, though your lordship is not called upon...
So your argument is that we forget about the legislation and we just homing in on Samiullah Baloch alone. So having said that, what's your argument to the effect that how do you put a time frame to 621F if we are not looking at legislation?
My lord, I would say that this lifelong ban has been brought in by the court. Even if this were to mean...
I think the decision doesn't talk about life ban.
My lord, my lord, your lordship is right.
It says it's not lifelong. It says it's not permanent. It depends on that particular declaration.
My lord, and declaration which has attained finality.
Oh. So you see, it
says that.
No. You see, if let's read it.
No, let's take a declaration which is from the Supreme Court, finalized by the Supreme Court. Then what?
My lord,
suppose, Mr. Makhdoom, if there is a declaration by the trial court and eventually upheld by the Supreme Court, and then this person puts in as an application for nomination papers, then what?
My lord, then again...
It is for life.
It's for life. My lord, even if it is a decree of a civil court, which has not been appealed, it's for life. This honorable court says, your lordship is right, my lord, I'm sorry for using a shorthand expression, that it doesn't say for life, but it says for the duration of the declaration. My lord, as counsel, I can never conceive of asking your lordship a question. Let me ask myself, can I conceive of a court which can then give a declaration that the previous declaration, which has become final and binding, is no longer valid? The principle of res judicata will come in.
The response is, if we declare or interpret a declaration, will it serve the purpose?
My lord, which declaration?
On the basis of which the permanent disqualification is...
My lord, if it is a
Samiullah case,
if it is a decree of a civil court, because that is what is envisaged in Samiullah Baloch, then the decree has attained finality.
Decree must be in the light of or keeping in view Article 62.
Yes, my lord, but there will be...
If it is declared or interpreted as such, will it serve...
If your lordship today looks at it, if we look at the language, consequence of permanent nature, and my lord, the word is there on page 437. A final decree has binding effect and is commonly described as a past and closed transaction having permanent effect. Therefore, the consequence of permanent nature, that is,
where are you reading?
My lord, page 436, the last letter on that page, A.
उससे पहले 3 लाइनें और भी हैं मखदूम साहब,
वो भी पढ़ते थे. A decree by a court of civil jurisdiction can grant pecuniary or specific relief, including a declaration with respect to a legal right, status, or legal character. Such a decree that is based on admissions or evidence and sustained by reasons attains finality after remedies before the higher fora are exhausted. A final, I'm very grateful, my lord, a final decree has binding effect and is commonly described as a past and closed transaction having permanent effect. Therefore, the consequence of permanent nature, that is incapacity, following a final and binding decree of a court of civil...
So obviously, the decree has been attained finality, and after filing appeal and exhausting all remedies, obviously it will attain finality. Even in the banking court, a decree has been passed, appeal has been dismissed, leave has been refused, and it attains the finality.
And my lord, YFD, if your lordship will look at paragraph 26, immediately after
why not read para 36?
My lord, I will, if your lordship will permit me to read 26 first.
You see, the final decision, the conclusion drawn, if you come to para 36,
my lord, yes,
on page 444.
Yes, my lord.
And also read the conclusion drawn by Justice Sheikh Asbat Saeed.
Yes, Madam.
I think they have made it, yes, there are sentences which refer to a permanency, but I think the final verdict, the conclusion of the court was that the disability, the disqualification shall remain till that declaration is enforced.
Notice. May I submit? Now, if there is a decree which has attained finality.
Let's talk about a declaration.
Well, a declaration, the court talks about, if your lordship will see.
No, let's take the example, if there is a declaration that is attained finality, what do we do with that for election purposes?
A declaration which has attained finality, a declaration which has become a past and closed transaction, how will your lordship reopen?
That's the point.
Your lordship, it cannot be reopened. And that is why they say it's a permanent, but if the declaration has now, it is envisaged that either because of my tawbah, I will go to the civil judge and say that now I have become penitent, give me a declaration. Now that declaration cannot come either under 42.
Mr. Uzair suggested that that could.
My lord, but which court? Mr. Uzair said he had the key. He's amicus, so I deal with him with kid gloves. He said we have the key, but where was the key? He never pointed out. He wanted a locked door because he disclosed his hand towards the end, because he said whatever your lordships will do, you will not reopen past and closed transactions. He also pointed out, my lord, since we are on that subject, that there was no time period specified in PO 14, and the time periods all came in subsequently under the 18th Amendment. With great respect, my lord, incorrect. When your lordship looks at PLD 85 federal statutes, except for a few provisions, the time periods are all specified there. Right. All the time periods are there. So that was not a correct submission, with great respect. That's contrary to the statute.
So, Mr. Makhdoom, keeping in view the Faisal Wawda's case, whether that permanent feature has been gone or it is still in field?
My lord, may I say that
there was no declaration.
There are times when a court, having made a declaration itself, which it did in Samiullah's Baloch case, your lordships have time to think and reflect and moved away. The author judge himself, in the Rind case, in the Shamona case, and in Khaja Asif case, moved away from the declarations which were made in Samiullah Baloch case. So I would say that these three judgments, while they couldn't overrule Samiullah Baloch, they considerably diluted the effects
so we
of
just
Samiullah
want your opinion on the fact, and what's your submission on the fact that there is a permanent decree or declaration. How do we deal with it for the purpose of election? How do we put the time frame or time limitation?
My lord, I would say that a reasonable time.
No, but then won't you say that this is now an academic question because Parliament has done your job?
Yes, my lord, and I would say how.
If that law is challenged, like you said, we look at it.
Yes, and my lord, the other thing is, if the statute was not there, if the statute...
Then we have to think of
then your lordship would have to provide a period.
If we were to say that if the statute is there, are we saying that the statute, the vires of statute is correct?
No, my lord. May I point out?
What are we saying?
My lord, if your lordship overrules Samiullah Baloch and do not touch the statute, do not hold it intra vires or ultra vires,
leave it for another day.
Today the statute is in the...
When you say overrule Samiullah, there has to be some sort of a time frame built in.
My lord, may I point out?
But that is the statute has provided it.
In spite of the fact that your lordship has not... In spite of the fact that your lordship has not struck down the statute or upheld the statute will remain in the field. So therefore today when a person goes to file his nomination papers, the returning officer is... The returning officer is confused because Samiullah Baloch says lifelong, the statute says 5 years. Tomorrow, if Samiullah Baloch is overruled, or today, if Samiullah Baloch is overruled, the returning officer, if I go to the returning officer and I say that this person should be disqualified because he has been imprisoned for 1 year, the returning officer will say, sorry, no, the time limit is 5 years. A person who has been convicted for 5 years may tomorrow come before your lordship and say that this statute is unconstitutional because it goes beyond the limits of 62(1)(f, that it is unreasonable, please strike it down. And in the face of that disqualification, your lordship may strike it down.
You're suggesting that we look at Samiullah Baloch alone and say that this unlimited period is not correct and that stands overruled. However, in the meanwhile, a statute has come, so we don't say anything about the statute. That will be challenged later, and we leave it there.
Yes. And then the returning officer...
Can I ask a unconnected question now? If you have concluded this thought, your thought. Have you concluded your thought?
Yes, my lord.
Your associate, Mr. Sikandar Bashir Mohammed, was a counsel in Samiullah Baloch.
My lord, yes.
I don't see, maybe I've missed it. Was an Order 27A notice issued to the Attorney General and Advocate Generals of the provinces?
I think it was. And my lord, Mr. Ashtar Osaf Ali,
he was in attendance, that I note.
He was in attendance.
But was a specific notice, because there are cases which hold that you have to give a specific notice, not a general attendance notice.
My lord, that is not apparent from the law report.
Does he know? For present, we can note it ourselves. File
my lord, it is clear.
Order 27 rule A ki notice.
My lord, it is clear that he was, if your lordship...
He was in attendance.
No, my lord, if your lordship looks at page 199 of the law report...
199 तो नहीं 400 कुछ हो
जी सर ये नहीं I'm looking at the wrong case I'm sorry
कौन सा
ये तो 400 से शुरू है
I'm looking at the wrong case I apologize this
number
is
7
4
पहले आप देखते रहें जब तक वो देख लेते हैं आपके साथी देख लेते हैं चलिए आप आगे बढ़िए ये देख लेंगे मोहम्मद साहब देख लेते हैं हाजिरी तो हमने नोट कर ली है
जी that's what
on court notice is different from order 27A notice जी
तो
वो तरह अगर आप देख लें
it only says that he is there on court notice.
How have you concluded?
My lord, my submission is on the question of...
Can you speed it up a bit?
My lord, if your lordship gives me 5 minutes, I'll wrap.
You can, but just...
My lord, now, besides the other problems, when Samiullah Baloch was dealing with the declaration, Samiullah Baloch talked about the doctrine of Tawbah and Af and forgiveness but doesn't deal with it and says that till such time that the declaration remains in the field. My lord, a declaration which is the result of a final determination will remain in the field till such time that it is undone by a court. Now, in the context of elections under Article 225, there is no court which has the power to do that. The ordinary civil court can't give such a declaration. The election tribunal can't give such a declaration. Even in the context of Section 9 and Section 42, there is no court which can give such a declaration, particularly in the presence of a decree of final nature, and therefore it is permanent. Now, they use the word permanent, and then they say there is, and my lord, look at the audacity of a civil judge who would then be prepared to give a declaration that this person has become penitent when the Supreme Court is saying that any other interpretation of the Constitution would virtually put the sanity of the person making such an interpretation in question. I can't conceive of a civil judge who would, in view of that kind of strong language used by this honorable court.
Let sanity determinations be determined by medical practitioners.
Yes, my lord.
It's best.
Yes.
We should not go there.
I was pointing out that practically.
Sorry, I think that's language is not appropriate.
My lord, yes.
And we are no one to determine people's sanity. Yes, there are mechanisms. We are not qualified.
Another reason, my lord, why your lordships won't take a look at 232 right now is, if 232 was a clearly unprecedented approach, clearly unconstitutional approach, then your lordships could have taken even notice yourself. But 232 is an approach which is justified by the practice of legislators the world over. What happens in the United States when a statute is struck down by the court? The states, legislatures, or the Congress at times passes another statute. And that way, you can say invite, or you can say they compel the court to revisit their previous judgment and to say whether this is constitutional or not. After all, in United States, legal tender or paper currency was held to be unconstitutional.
But Mr. Makhdoom, leaving aside 232 would also be a bit of a challenge in the sense that this provision, as submitted by Mr. Faisal Siddiqui, has actually been brought in to nullify Samiullah Baloch. And we are examining Samiullah Baloch. There is a legislative intervention to nullify the judgment. We will not take any notice of that provision.
My Lord, may I point out, if your Lordship overrules Samiullah Baloch, and that is what Mr. Faisal Siddiqui also submitted, if your Lordship overrules Samiullah Baloch, then that conflict disappears. There is no longer a judgment of this honorable court which is in front.
You want us to hold that we hereby overrule Samiullah Baloch and stop. Nothing more. Nothing.
Your Lordship is not called upon to do anything.
I'm asking you.
Yes, my Lord.
Will that not be a bit odd?
No, my Lord, because the statute is not in the challenge in the appeals before your Lordship.
Let's say you've created a void now.
No, the void is filled according to you by 232 till such time as challenged.
We have to refer to the statute.
My Lord, tomorrow
it is challenged.
Tomorrow a person may come to your Lordship and say that I was convicted and sentenced to a period of 5 years and my nomination papers have been rejected. This limitation imposed by the legislature on 5 years is contrary to 62(1)(f) of the Constitution, because the legislature has put in an interpretation of the Constitution which is unreasonable, and your Lordships need to strike it down, and your Lordship will then look at 62(1)(f) and 232 and will have an opportunity to strike it down when a real petitioner with a real grievance brings a real controversy to this court. That issue is not before this
court. But all of Pakistan is happy with the law because no one has come forward?
Yes, my Lord. And therefore...
Can that be implied because we gave public notice and sufficient time as well?
Yes, my Lord.
And we were actually expecting a challenge to be thrown.
My Lord, somebody could have come in under
in response to public notice. Makhdoom Saab is before us, and
others could have come in even in a 184(3) petition challenging 232.
की जो लाइफ है वो 5 साल कर दी है, जो डिक्लेरेशन आप 62(1)(f) में पढ़ते हैं ना
जी सर,
उसकी लाइफ 5 years कर दी उन्होंने.
एक और clarification that you trying to say that had there been no 232, then we had to go the extra mile and come up with that reasonable time. But now,
would you then agree with Mr. Faisal Siddiqui's thing that you can look at other things as has been done by my Lord himself, and in the presidential thing 91(4) or something was mentioned, gets 5. That was. Would you agree with that interpretation?
My Lord, yes.
My exercise is not required.
My submission is...
We don't need to do that.
My Lord, my submission is that in that situation, your Lordship would have done the exercise had there been no Samiullah Baloch and said, we will read 63. The legislature never envisaged more than 5 years for anyone. Even somebody who had worked against the integrity of Pakistan has to be brought into the political processes of the federation so as he is integrated and his political party is so integrated, and therefore 5 years is the maximum. You can't go beyond. My Lord, a recent judgment which has come out from Australia is very interesting. In Australia,
is it in your book?
My Lord, it is not, because it's the result of yesterday.
You have copies?
Last night. Yes, my Lord. Sir?
What's the judgment?
My Lord, in Australia, now the world over there's a problem of illegal immigrants. In Australia, the issue which arose was, it's a long judgment, but I'll briefly explain what it was. The issue which arose was that here was a Rohingya Muslim from Myanmar who, given what was happening in Myanmar, has been able to get to Australia, and he was detained in the immigration's detention center. The law provided that the person will remain in the detention center till he is given a visa to be in Australia, or he is deported back to his country or to another country. Initially, he was allowed out of the detention center. Then, and it's very serious from the point of view that he committed an offense against a child. And for that sexual offense, he was put back into the detention center. The commission then examined whether he should be released or not. And the answer was he should not be released. He filed a writ, which was the administrative tribunal upheld that. He went to the federal court upheld that. Now the situation was this. He couldn't go to Myanmar. He was Rohingya Muslim. Myanmar wouldn't take him back. He had relatives in Bangladesh and Saudi Arabia, but there was no prospect of him being sent or those countries accepting him. The history of Australia suggested that whenever they had tried to send somebody who had been accused and convicted of such an offense to another country, no other country was prepared to accept him. So now the law did not provide any outer limit. The court said the moment it is clear that he cannot be sent to any other country, he has to be released and the detention has to come to an end, and you can't keep him detained forever and ever. There has to be a reasonable time for such
What's the connection with this case?
My lord, the connection is reasonable time. Even in the case of a convicted offender for crimes against the child, he could not be denied of all civil rights, and Australia doesn't have a chapter on fundamental rights, so they talk about civil and common law rights. He couldn't be denied civil and common law rights forever and retained forever. The other common factor is that there was an earlier decision known as your lordship goes through this judgment, your lordship will see, in the case of Qazi. In the case of Qazi, the Australian High Court had said that that person can continue forever. They revisited it and they said that declaration was contrary to the Constitution of Australia.
But Mr. Mathur, your submission is that Samiullah Baloch is to be overruled on the ground that there should be a reasonable time rather than unlimited time. And to carve out that reasonable time argument, your submissions are, in summary?
My lord, my submission is that Samiullah Baloch should be overruled because it reads into 62(1)(f) a civil liability, a declaration of a civil nature, which for the life of the declaration disqualifies a person and thereby strips him of his fundamental right under Article 17 of the Constitution. My lord, I have not used the word lifetime now advisedly.
Mr. Makhdoom.
Sorry. My lord, so that's the first submission. The court talks of the doctrine of Tawbah, but then and says this declaration will remain in the field till it is so removed, but does not identify a forum or a law under which this declaration could ever be undone. So neither it identifies a statute, nor it identifies a forum under which would undo this declaration.
Does not identify forum or
mechanism or the law. A law under which such a declaration can be made and a forum which will make that declaration. They don't identify, because my respectful submission is neither such a law nor such a forum exists.
That means that Samiullah Baloch is talking about a window that is through Tawbah for the purpose of election. Yes. Even otherwise, inter parties, the declaration stays.
Yes.
But they're also realizing that for elections there could be a Tawbah system.
Yes.
But that system isn't really there.
That system is not there, that law is not there.
And the judgment talks about mechanism.
It's not there, and my lord, as my lord the Chief Justice identified, this cannot be looked into without looking at Article 175 of the Constitution. When your Lordship examines Article 175, paragraphs 1 and 2, all courts, including this Honorable Court, has only such jurisdiction as is conferred upon it by any law or the Constitution. And that law is not identified, that constitutional provision is not identified.
You mean to say that no special court has been constituted for 62(1)(f)?
My lord, even under 62(1)(f), if a special court is constituted, it has to be done under a law. There is none. So your lordships and no civil court will have a jurisdiction which is not given to it by the Constitution or the law. So
9 of the CPC is procedural or substantive?
My lord, even if your lordship looks at section 9 CPC as substantive, a section 9 CPC code will not, in the face of a decree which is described by, or declaration, I don't use the word decree, declaration which is described by this Honorable Court as permanent and past and closed transaction, applying the principles of res judicata, will not issue a declaration that this declaration no longer applies to this person.
Is that it? Anything else?
My lord, that is it. And
just one more question. Is there any material which sort of talks about the importance of elections in the sense that people convicted or people having decrees against them, there's this cooling off period and after which they can jump into the ring again? I mean, conceptual framework of this, any material, anything that elections require, that even if you were a convict after a cooling off period, you're still, I mean, democracy requires that you come back into the ring again.
My lord, history gives you that example, which I gave your lordship 2 examples very recently, that history gives you that example. Besides history, I haven't come across, but I'll look for it. My lord, my last submission was, and that's the formulation, that it was submitted yesterday by one of the amici, that your lordships will make this judgment, he didn't say that in so many words, prospective, and it will apply only now to the current election disputes, but it will not do anything about people who had earlier been disqualified as a result of Samiullah Baloch or earlier case law. The submission over there would be that if your lordship was to go down that road, your lordships will be creating 2 classes of citizens in the country, those in whose case a declaration has been made earlier and they have been stripped of their fundamental rights, and those whose fundamental rights are threatened now.
एक चीज मखदूम साहब इसी से रिलेटेड जो सवालात हो रहे हैं जी, जो समीउल्लाह के केस में आया है वो ये आया है कि जब तक वो डिक्लेरेशन कायम और दायम रहेगा, जब तक उसका डिस्क्वालिफिकेशन रहेगी। अब ये जो नया लॉ 232 में आया है, कैन वी रीड इट लाइक दिस कि ये जो वो वाली बात थी वो उन्होंने परमानेंट नहीं कहा, उन्होंने कहा एज लॉन्ग एज द डिक्लेरेशन विल रिमेन इन फील्ड। हम ये कह सकते हैं कि इस लॉ के आने के बाद उस डिक्लेरेशन की मुद्दत उन्होंने 5 साल कर दी।
सिर्फ इलेक्शंस।
Yes, my lord, your lordship
to the extent of election.
Your lordship may, but my respectful submission remains. My respectful submission remains that your lordship.
You are very hesitant to go that path.
My lord, I spent several days unsuccessfully arguing in another case, so I'm in a way, I have got a mental block saying that a statute, my lord, your lordship's judgments are there. Your lordship will find every reason to uphold the validity of a statute. Even only when reasoning completely fails your lordship, would your lordship strike it down. When there are 2 interpretations possible, your lordship will give an interpretation. The burden of proving a statute unconstitutional is upon the person who comes to this honorable court and says this statute is unconstitutional. Now, in order to apply those, now even if your lordship is to uphold the statute.
It was just a comment.
No, my lord,
with your.
No, but one more question which arises from that is that there's a bit of an unease when we look at 232. Can, through sub-constitutional legislation, the constitutional provision be controlled? I just want your comment.
My Lord, my submission is two.
Maybe we have just considered this very point in the Supreme Court Practice and Procedure
Yes, Your Lordship.
Act, which was a full court where the right of appeal was created by statute, not by the Constitution. Is that an answer or not an answer?
My Lord, that's one answer, and Your Lordship gives another answer in that case as well, where Your Lordship...
That judgment is binding on us.
And Your Lordship says that we will not deal with academic questions. Questions which do not arise, we will not decide in this case. Number of issues were raised. Your Lordship's in the penultimate paragraph, Practice and Procedure Judgment.
Yeah, it was very interesting hearing. It was,
Your Lordship,
we would have loved to, but
no,
like you said, save it for another day.
Yes, my Lord, and I would therefore say, my Lord...
Can you also just, I know it may be imposed, give a little write-up today?
My Lord,
not too long, just precise what you formulated, so we don't want to miss anything out.
Before leaving the rostrum,
he has the right job.
You are a mind reader.
My Lord,
have you done it already?
That notice there, Your Lordship may also take a look at this chart, and then I leave the rostrum. Paragraph 34 of Your Lordship's judgment, full court judgment, having found the Act to be fully compliant with the Constitution, there is no need to consider the other points raised by the petitioners because the same will have no bearing on the outcome of these cases. So a declaration as to 232 will have no bearing on the outcome of these 185 appeals. If Your Lordship overrules Samiullah Baloch, the disqualification will get removed. If Your Lordship confirms Samiullah Baloch, the disqualification is then upheld.
इसको read down क्यों नहीं कर सकते?
My Lord, because the issue is not before.
वही बात वही आ रही है ना कि उसमें permanent disqualification तो नहीं है. उसमें लिखा है as long as the declaration will remain in field. अगर by legislation उसको वो कहते हैं कि declaration की जो मुद्दत है जो उसमें लिखी हुई है उस 62F के अंदर वो हम 5 साल कर रहे हैं. तो वो फिर उनका jurisdiction है या नहीं है?
My Lord, academically I would say yes, but practically I would say that Your Lordships will perhaps do that in a proper case where somebody challenges that before Your Lordship.
No, we are just approving. The challenge तो नहीं हो रहा हमारे सामने. उसकी legality पे तो हम बात नहीं कर रहे हैं ना, वो तो एक in existence है law, उसके ऊपर बात कर रहे हैं.
जी chart. My Lord, Your Lordship may also look at a chart which I have briefly done, which basically, Your Lordship has that chart before you. Your Lordship will see I have put on the left-hand column judgments with members of Parliament were disqualified and judgments where members were not disqualified. And Your Lordship will see, particularly when Your Lordship will see the case of Imran Khan Niazi is here, Sheikh Muhammad Akram, a judgment authored by my Lord the Chief Justice is there on the right-hand side column. If Your Lordship turns the pages, Your Lordship will see after Samiullah Baloch, there are several judgments. The case of Shakil Awan, the case of Roshan Ali Bariro, the case of Khaja Muhammad Asif, the case of Sardar Muhammad Rind, or in the case of Shamuna Badshah, the case of Faisal Wabda Lasti, where the learned author judge of Samiullah Baloch has slowly moved away from the rigors of the Samiullah Baloch test. So therefore that shows that there was a judicial realization without overruling by the author judge himself, because he couldn't overrule.
Maybe the council had argued better.
Maybe that's true, sir. But Samiullah Baloch therefore stands considerably diluted. Now Your Lordship need to pull that jurisprudence together, because there are judgments for, there are judgments against. Your Lordship has to see if Samiullah Baloch is incorrectly decided, then there is no bar under 62(1)(f).
Anything else?
That's it.
Mr. Maghlub, before leaving the roster,
ये आप points अगर जो आपके articulate अगर एक छोटा सा 1-2 पेज पे अगर आप हमें दे दें during the course of the day.
Sir, it will be done today.
एक जरा सी फैक्चुअल बात भी है, सवाल पूछ रहा हूँ. क्या जितनी भी जजमेंट्स आई हैं जिसमें समीउल्लाह बलोच को इम्प्लीमेंट किया, इवन समीउल्लाह बलोच में ही, क्या किसी भी केस में किसी सिविल कोर्ट से ऐसी डिक्लेरेशन आई है कि जिसके तहत उस शख्स को डिक्लेयर कर दिया हो कि वो नहीं, और उसकी बुनियाद पर उसको लाइफ डिस्क्वालिफिकेशन और वो ने किया हो?
No, madam. No, madam. Not that I am aware of.
Just adding to the query, has any court revived the ban or removed the ban? To kind of through court of law, like a court of law can give a declaration, court of law gives a declaration, okay, now you are honest, Amin. मेरे नजर से ऐसा केस गुजरा नहीं.
There is not a single case. Civil judgments are not reported, so I'm not aware. But there is certainly nothing which was reported in the High Court. And my lord, a High Court judge would be particularly very worried of undoing such a declaration because he would worry under 209(25) of the Constitution, that 25A, that his sanity may be called into question, and therefore he's continuing to hold the office.
एक बात और सबीउल्लाह बलोच में
Why you calling the sanity of judges into question or not counsel as well?
Yes, my lord.
ये आप हम पे ही सब डाल रहे हैं.
Sir, नहीं, फर्क ये है कि I know, if my sanity is called in question, that doesn't lead to a loss of office.
Mr. Maktoum, जरा ये बताना Mr. Maktoum, ये सनाउल्लाह बलोच में जो पिटिशनर है या रिस्पोंडेंट उस केस में थे, उनके बारे में कोई लफ्ज कहा गया कि उनके बारे में ये डिक्लेरेशन इवन सुप्रीम कोर्ट ने कोई दी हो? जस्ट प्रिंसिपल उन्होंने कह दिया.
My lord, it hasn't been said that they are profligate or they are dishonest or they are not Sadiq or Amin.
Nothing has been said against the.
There is no such declaration. And your lordship will see the disconnect. Mia Mohammad Nawaz Sharif is disqualified for not for a.
I don't want involvement of names. We are only doing with the Constitution.
Let's not give a name, my lord. A person is disqualified.
We don't want to make it a political.
A person is disqualified who has not drawn a salary because the salary is regarded an asset. A person is disqualified.
That case is not before us.
Because he's a trust, which trust his children had declared he is not, but a person is not disqualified.
Maktoum Ali Khan, the first rule of counsel is don't argue a case for which you've not received a fee.
My lord, I have finished my submission.
Okay.
Thank you.
Has everything been said or you want to add?
I want to say.
How long for?
I'm in your hands, but...
No, we don't want to stop you.
I
Just tell us.
understand there is a reference at 11:30. I try to wrap up by 11:30.
There's a break also.
थोड़ा ये नहीं कि आप हमें वहाँ तक खींच के ले जाएं. ब्रेक भी या तो हम उसके बाद बैठ सकते हैं. अगर आपके पास लंबा वक्त है तो हम उसके बाद बैठ सकते हैं.
जी ठीक है.
तो आप ज्यादा टाइम लेंगे?
जी मुझे कुछ तो लगेगा.
अच्छा, किसी तो हम पूछ रहे थे कोई और तो नहीं है? एक साहब थे, उनको कुछ कहना था कि हम कम से कम सबको खत्म कर लें, फिर आपको रहने देते हैं. जी.
Well, I have two CMs, CMA 3 and CMA 21.
क्या चाह रहे हैं इसमें?
Sir, इसमें I filed the concise statements in response to the orders passed by the Honorable Court. So I adopt the arguments of Mr. Maktoum Ali Khan. Thank you.
You are supporting the law. Supporting the law, na?
As is argued by Mr. Maktoum Ali Khan.
आपका नंबर क्या है?
CMA 3. CMA 3
और
and 21.
21.
Yes, sir.
ठीक. ओके, आप हो गए. और
एक CMA 22 सुप्रीम कोर्ट वाली वो मैंने विड्रॉ करनी है, इंस्ट्रक्शंस विड्रॉ.
अच्छा, विड्रॉ
चैम्बर
हम देख लेंगे. ठीक है. और
योर ऑनर, मेरी CM 18 है. मुख्तसर सी सबमिशन है कि when the legislature through 18th amendment introduced declaration in the Article 62, Parliament presumed that everyone is honest, everyone is Amin, everyone is non-profligate, and unless there is a declaration, he shall be presumed as such. So this was the basic presumption, and that is rebuttable. Anyone who want to rebut that,
आप अपना बताएं ना, आपका क्या मौकिफ है?
जी, जो अभी ला है उसका
आपका मौकिफ क्या है?
मेरा मौकिफ ये है कि बिल्कुल हर आदमी सादक अमीन है जिस वक्त तक के साबित
लेट्स प्रूवन अदरवाइज.
यस. और फिर जब वो उसने कोई ऐप कर दिया एक दो इंस्टेंसेस से,
एवरीबॉडी इज अज्यूम्ड टू बी इनोसेंट अनलेस प्रूवन गिल्टी, दैट सॉर्ट ऑफ कांसेप्ट.
और फिर एक दो इंस्टेंसेस से कोई झूठा भी नहीं हो जाता. एक दो इंस्टेंसेस पे अगर वो फजूल खर्ची करता है वो प्रोफिगेट भी नहीं साबित हो सकता. एक दो वाकयात से नहीं, ये उसका मुसलसल कंडक्ट साबित करेगा डिक्लेरेशन के टाइम।
और ऐसा हर शख्स गलती का पुतला है।
बिल्कुल। और जब डिक्लेरेशन आ भी गया तो फिर भी तौबा के दरवाजे के लिए उन्होंने मुद्दत मुकर्रर कर दी 5 साल वैलिडिटी, जैसे किसी लाइसेंस की भी वैलिडिटी है, उस डिक्लेरेशन की वैलिडिटी लेजिस्लेचर ने 5 साल कर दी है। अब 5 साल के बाद अगर कोई आदमी फिर भी कहता है कि ये सादक अमीन नहीं है तो वो दोबारा जाके डिक्लेरेशन ले ले कि इसको 1 आ गया डिक्लेरेशन, इसने फिर भी अपने आप को तौबा के दरवाजे तक नहीं लेकर गया, अपने आप के अपना रास्ता मेंड नहीं किया, he is not married and he is still not सादक and अमीन, और he is still profligate, he is still dishonest, तो वो ले आए दोबारा, वरना 5 साल के बाद दोबारा प्रिज्यूम ये किया जाएगा कि ये इसने तौबा कर लिया।
थैंक यू जी।
CMA 135, my lord. May I adopt the arguments by the party? And I support the law.
CMA number?
CMA number 135.
अच्छा, ठीक है।
22.
ओके, ठीक है। Short and sweet. Next.
I'll just briefly
number बता दें।
My lord, it's civil appeal number 1946 2020. 1946.
Civil, आपकी civil appeal है।
Civil appeal, my lord, of 2020.
You are supporting Samila Baloch or opposing?
I'm opposing.
Opposing Samila Baloch.
My lord.
So you adopt everything said?
My lord, but just briefly, if I can just
want to add anything, बता दें।
My lord, if I may just refer Article 62(1)(f). And I just would like to add that this article is conjunctive and not disjunctive. So all the requirement mentioned in F, sagacious, righteous, non-profligate, honest and amin, has to have a degree of all of it. My lord, because it's not or, it's and. This is my humble submission.
Okay, conjunctive and not disjunctive.
My lord. Number one, and my lord, in this regard, there is no such declaration till today. At least I have not come across. However, so many people have been disqualified. There has not been declaration to this effect in Pakistan.
Conjunctive नहीं हुआ है
or even otherwise. There has not been a declaration saying that this X person is not Sadiq Amin or honest. Further, my lord, I would like to state Article 63(1)(h), which talks about has been on conviction of moral turpitude. In my humble understanding, I would say that if somebody is convicted in this, say for example, somebody is a thief and is convicted for it, then he's automatically disqualified under 62(1)(f) also. If he's a thief, how could he be honest and amin? My lord, and further, I would like to say that Article 62(1)(f), the declaration to this effect cannot be given by constitutional courts, and it can only be given by the election tribunal. And because declaration has to be on finding of fact, after leading evidence cross, because if it is held today that under Article 199...
Evidence has to be led.
My lord.
And cross-examined right has to be provided.
My lord, because if you are declaring somebody not honest...
Article 10A requirements.
Article 10A requirements, exactly.
Forum is tribunal.
My lord.
मतलब जो भी फोरम है उसमें ये तकाजे पूरे करना चाहिए, एविडेंस लीड हो, क्रॉस एग्जामिनेशन हो, राइट टू लीड एविडेंस इन रिबटल हो.
My lord.
ठीक.
Now, my lord, quickly, if I just come to Samiullah Baloch's judgment and take my lords to page 442, para 32.
Ji.
In this, it has been stated that declaration by court of civil jurisdiction at para 32, 5th line. They have said that it has to be declaration by court of civil jurisdiction.
Paragraph 32.
32, my lord. In my humble opinion, that would be...
कहाँ से पढ़ रहे हैं?
My lord, 5th line है. 1, 2, 3, 4, 5th line.
पढ़िए. हाँ, civil jurisdiction as declared
by court of civil jurisdiction. So in my humble, in my submission, that would be violative of Article 225 of the Constitution, which says no election dispute can be brought in question other than by election petition. And
civil court can declare before election, even if no dispute of election is there, somebody can be declared.
My lord, in my view, that is why that has been safeguarded, so that the parliamentarians don't have to be stuck with these court cases throughout their 5 years tenure. Why election tribunal? Because only the contesting candidate can challenge those elections. Here,
even if civil court declares somebody, then still the tribunal can decide about it.
My lord, in my view, if civil court, anyone can go and take you to the court, and all 5 years of your tenure, you will be busy in courts proceeding only. Whereas in election tribunal, it's only the election candidates who have contested the elections, they can challenge that election. Mr. My lord, at page 443, if my lord would see para 34. If I may just quickly read this, my lord. In the post-18th constitutional amendment scenario, an adverse declaration by court of law against a candidate necessary to oust him from an election. It was held in Abdul Ghaffur Lahiri versus returning officer that a false declaration made in nomination paper by a candidate about his academic qualification led to permanent embargo on the candidature for election. This is because Article 62 of the Constitution did not provide any period for which a person would stand debarred from contesting election, and therefore the appellant before the court could not become qualified merely by efflux of time. To the same effect is the judgment of Mohammad Khan Junejo versus Federation of Pakistan, appellant before you, my lord, wherein a deficiency in qualification under Article 62(1)(f) of the Constitution led to permanent disqualification. This outcome was followed in Allah Dino Bhayo's case, 2013 SCMR, in which the following observations were made in respect to duration of embargo. In this Allah Dino Bhayo case, relying on Mohammad Khan Junejo's case, who was appellant before my lord, it was said that this disqualification will haunt him forever. However, what happened after that in 2020? Supreme Court 591, relevant page 15, 597.
G.
Class item A, my lord. The para 5, the upshot of the said judgment is that a disqualification under 62(1)(f) of the Constitution can only be imposed by or under declaration made by court of law. By such prescription, Article 62(1)(f) creates a lawful, transparent and fair mechanism for an election candidate to contest an allegation that he is disqualified under one or more of the ground listed in the said constitutional petition. Accordingly, in the case of Sardar Yar Mohammad Rain, this court held that judicial declaration disqualifying a candidate under 62(1)(f) of the Constitution must necessarily be based on oral or documentary evidence. In case reported at Imran Khan Niazi versus Mia Mohammad Nawaz Sharif.
Point kya hai?
My lord, point is, my lord, at para 7, I was just showing that this was the view. From here, the view started changing. At para 7, if my lord would see at the next page, third last line.
G.
The said impact of the 18th Amendment went unnoticed in our judgment under review, dated 9/7/23, thereby constituting an error apparent on the fact of record. What I would like to say here is, my lord, in this case, they realized that this was an error apparent on record, and they reviewed their judgment of 2013, which was passed relying on our appellant's judgment. But appellant and rest, everybody else was left there. In this case, this judgment was reviewed and that judgment was set aside.
The Bhayo review was after Samiullah Baloch.
My lord, 2020.
Achha.
My lord. And Bhayo was passed relying on the judgment of Mohammad Khan Junejo's case.
Bhayo review after Samiullah Baloch.
After Samiullah Baloch.
And a different point of view was taken there.
Yes, my lord.
What was the view there?
The point of view was that after 18th Amendment, the Supreme Court had not realized and Supreme Court had declared.
To kya hold kya?
Hold kya, they set aside that judgment and said that in post 18th Amendment scenario.
Disqualified or qualified candidate?
He's qualified.
Disqualified.
Qualified. Earlier in 2013 he was disqualified. In review judgment in 2020 it was held that it was a mistake.
Okay, understood.
Because there wasn't a declaration from
we will read it. Thank you.
So this was the case and in this I was saying that in Mohammad Khan Junejo's case, in which Bhayo was disqualified, Bhayo case was reviewed and rest everybody was left there.
ठीक. ये रिव्यू वाली बेंच कितने जजेस की थी?
My lord, 3-member bench.
ठीक.
And in Yar Mohammed Rind, it was also 3-member, but all 3 members were same as in Samiullah Baloch case. Now, my lord, if I may just quickly take my lords to Faisal Wavda's case 2023 SCMR 370. Paragraph 4, my lord. Sixth line. He admitted that he was disqualified from contesting the election under Article 63(1)(c) of the Constitution on the date when he had filed nomination papers for the election of NA 249 Karachi, and that his affidavit filed with the nomination paper thus contained an erroneous statement, which he regrets. In order to demonstrate his good faith and remorse for his mistake, he undertakes that he will resign from the office of member of the Senate to which he was elected. Then next para, second last line, it is clarified that petitioner shall not be considered disqualified in any subsequent election on the basis of instant matter. In my view, my lord, this was in my humble view, this was the correct view taken rather than Samiullah's Baloch case.
Thank you. Conclude.
My lord, इसमें सिर्फ एक last one. Section 232(2), my lord, though the Bairis are not challenged and not before, my lord, I would like to state that this 232(2) does not take anything away from Article 62(1)(f).
It accords with Article 60.
My lord. And my lord has already pointed out.
We have not pointed. We just observe.
No, reliance is also placed on the Supreme Court's procedure judgment.
Okay, that point.
My lord. This is all.
Thank you. क्यों कहीम साहब कुछ रह गया? आप थके हुए लग रहे हैं.
I'll just take 2 minutes, my lord.
जी बता दें. कौन से केस में आप?
My lord, I'm in Civil Appeal 880.
880. Which proposition are you supporting?
My lord, I'm supporting the law.
The law. As always, you support the law.
My lord, I'm submitting before my lord that Article 17 has been interpreted by this honorable court in the Benazir Bhutto cases. Muhtarma Benazir Bhutto cases.
Article 17, Benazir Bhutto case is 19.
My lord, there are 3 of them, my lord.
Which one are you referring to?
To include the right to, my lord, right to contest elections and all of the
citation दे दें.
Sir, the first one was PLD 1989 Supreme Court's.
Which one are you referring to?
My lord, I am referring to, my lord, PLD 1998 Supreme Court 388.
1998 Supreme Court.
388.
Which page?
At paragraph 165, my lord.
Paragraph 165. ठीक है हम पढ़ लेंगे.
My lord, इसके अंदर ये होल्ड किया गया है कि fundamental right to it includes the Article 17 includes the right to contest elections as well. Right of association के अंदर add किया गया. I'm submitting before this honorable court that 62(1)(f) की sir जो declaration है, the declaration is about one point in time. It cannot be said that even if it is permanent, it states कि उस particular time के ऊपर आप सादिक और अमीन नहीं हैं. It cannot be held कि there is no principle of original sin in Islam. That अगर एक दफा आप बीच में हो गए तो वो बाद में नहीं हो सकता. What I am submitting before this honorable court is that the entire tenor of the election laws, अगर Elections Act 2016 देखा जाए और अगर रोपा भी देखा जाए सर, उसका जो section 67 है वो disqualification के बारे में बिल्कुल बात नहीं करता. वो election को set aside करने के लिए सर बात करता है. Disqualification is used as a basis for setting aside the election once. I am respectfully submitting that any disqualification which follows from such an interpretation or a declaration, if such a declaration could be given, would only be one time and would double punishment nahi ho sakegi is particular case ke andar. And I'm also submitting before this honorable court that in the Mubashir Hassan case, the NRO judgment, it was specifically stated that 62(1)(f is not a self-executing provision. What is relevant is the mechanism for its enactment, जो कि impugned जो law भी जनाब के सामने मौजूद.
हसन वाला केस की citation.
My lord, Mubashir Hassan. It's at page 423, and my lord, the citation is PLD 2010 Supreme Court 265, paragraph 115.
Para 115.
My lord, and it was stated that this is not a self-executing provision. In fact, a mechanism has been provided, and the law which is before my lords has stated कि इसका procedure और forum provide किया जाएगा. सिर्फ टाइम को उन्होंने टच किया है, but they have not gone ahead and provided the provision. So my respectful submission would be that the forum which is under 62(1)(f to give the declaration is yet to be provided. No redundancy is being attributed to the Constitution. However, the mechanism which is supposed to be provided is yet to be provided by the legislature. My lord, on the issue of Tawbah and Afo Darguzar, I have actually done some homework in provisions of the Quran. I have actually Mukhtalif surahs I have highlighted. I'm tendering the same before my lord in my concise statement.
Thank you, will be most useful.
Thank you very much, sir.
ये ले लें इनसे. ठीक है, तो we come to the Attorney General at 11 after the
Supreme Court bar.
हाँ, sorry.
सर सुप्रीम कोर्ट सर हम विड्रॉ करना चाहते हैं सर हमारी चैम्बर अपील.
आपकी क्या चीज थी? 184 था?
हमारी 184 था.
अच्छा, okay, you are withdrawing.
जी सर.